you are the director in your trial. You are the one that is going to be leading your witnesses and your experts into where they fit in and how much they should say or not. So hopefully, you're meeting with your experts before, as you're developing the testimony that you want from them, and then you're talking to them again. It's not just one time, it's probably several times over the case and certainly in your trial. And so you really need to know your expert, know where they tend to want to talk too much, especially with your psychologist and neuropsychologist, maybe psychiatrist, and kind of give them more direction on where that should go, and then hope it works when they're up on the stand. And if they're not following it, then maybe you take a break. And then at break, I certainly will tell them.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and noble practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share this conversation with Debra Bogaards. Deborah pivoted from her career as a talented trial lawyer handling both plaintiff and defense cases into full-time mediation. She brings that trial lawyer preparation and focus to her mediation practice, mediating all types of cases. Deborah also serves on the faculty for UCL Law SF, formerly known as UC Hastings College of the Law, teaching negotiation and settlement. As someone who has been on the other side of Deborah in litigation, as well as a participant in her mediations, I can attest to her quick, steady capabilities in identifying the key issues in the heart of a dispute. Her meticulous preparation includes working with the parties in advance to make sure the work has been done and the right decision makers will be there. For us, her advanced work has led to cases resolving for policy limits before the mediation even occurs. We discuss Deborah's approach to cases before, during, and after a session, and how to set the stage for success. So please sit back and enjoy this wonderful and expansive conversation with the inimitable Debra Bogaards. Welcome to the show, Deborah.
Thank you for having me, Miles.
Well, it's really a pleasure. I've been looking forward to this.
Me too.
I wanted to start where I oftentimes do with what was it along the course of your life that made you decide that becoming a lawyer was something that you might be interested in?
I didn't have any examples in my family. We should probably start there. My mother and father got married and dropped out of college, came from the East Coast to the West. So I didn't have any examples of lawyers. But when I was in high school, I was concerned about women who were the victims of rape. I had read a few books and decided that I wanted to be a lawyer to help people.
Where was it that you grew up?
Culver City, which back then I would say it's on the way to LAX. Now it's becoming something because they've had a revival and it's near Sony Pictures. But back then it was like we had an ice skating rink, we had Bob's Big Boy, and that was about it.
I just drove through Culver recently, and it is quite nice now near Sony. Yeah,
different. Yeah.
How did you end up acting upon that? Where did you end up going to law school?
So that was easy. I graduated early from college, or from high school, actually. I graduated when I was in the beginning of my 12th year, and I went to UC Davis and learned I don't have a family in agriculture. My mom wanted us to be 3 siblings to be business majors, so I transferred to Cal undergraduate. And I used to look at San Francisco from our balcony, look at the twinkling lights and think, I think I want to go to law school there. And so I was very fortunate. I got into Hastings, now UC Law, which was the oldest law school at the time in California, and was thrilled to go there.
And from there, how did you then evolve into your first job?
That was pretty interesting. I was interviewing in Southern California to move back home, and I had a clerkship at Dorr Cooper and Hayes, which at that time was a Maritime firm in San Francisco. And my friend said, why don't you just stay here? I thought, why don't I just stay up here? I love San Francisco. So I started working there. We did maritime work, and I committed to San Francisco because I bought my first sweater and my first coat. You
live in a 2-lawyer household.
Actually, right now, even 3. Yes, my husband and I are both lawyers, and we have 2 daughters, Jamie, who's now 36, and Danielle is 35. And Danielle, her husband, Sam, their big dog, Cato, and their little Olivia, who's 13 months old, are living in the apartment downstairs while their home is getting remodeled in Tiburon. So right now, we're a 3-lawyer home.
Okay. Well, my direction on it was a clumsy way of asking if you and Peter met when you were in law school or if you met somewhere along the way.
We did. I got my MRS in a post-JD program. I had gone to a program through McGeorge, which was in Salzburg, Austria. And I was looking to do maritime law there. Peter had just graduated from the rival law school, USF, and he wanted to practice in the Netherlands where he was born. His family moved out to California when he was 5. And so we met the first day of the program.
I took us off track in terms of your maritime practice. So tell us a little bit more about that.
So when I was in Dorcas and Hayes, I did all maritime, and then I left to go to Europe on this program, and it placed you in a host law firm. And I actually really wanted to be in Rotterdam for Loof and Van der Bloek, which was a foremost maritime firm. But they placed me in a company or corporate law firm in London. So from there, a Queen's Chancellor I met showed me the way to Holman, Fenwick and Willen, which was a large maritime firm. And I worked there for a little under a year.
It's interesting that because I will confess, well, I think I know you fairly well, and I know your background. Maritime was not something that I was aware of. So you pivoted. Can you explain why?
Well, I had no sailing experience, no boating experience. I did more ship owner financing when I was in London. I actually got to go to the House of Lords because the partner I worked for was called to a ship scuttled in Dubai. So I got to go in the restroom and take the toilet paper that said House of Lords on it. It was a very exciting time. But when I came back, San Francisco wasn't a big port city. And I wanted to start a family. So I went to Pete Mark Mitchell, which is then a Big 8 law firm or CPA firm that I had worked for in college. And I went there to just get a letter of reference from someone I worked under. And he asked if I would come to their new international tax department. So the idea of staying international sounded great to me. And I was there for about 3 years until I realized I really wanted to be in court. I really wanted to take depositions and anyhow, oral advocacy. So I left there and stumbled into asbestos. I have to say it's where a lot of female attorneys got their start back then. Good group of people that are doing it. And I did that for a couple of years at Fisher & Hurst. I didn't like general orders, or the subject matter after a while was hard for me. You'd go to someone's home who was dying from mesothelioma, and I didn't want to spend their time taking their deposition and doing that. So I segued from there to my first kind of insurance defense job with Morton & Lacey. And I did Ringling, Brother and Barnum Bailey cases, and crazy and wild. And what I learned was I am good at and love depositions. I love talking to people. And, Anita, we would say peeling the layers of the onion in terms of getting more and more of their stories or vignettes. But I absolutely loved it. So that started and launched me on my career of doing more tort law.
There are two things I want to follow up on, and one is a little bit back. So I'll remember that one. I don't know that I'll remember the Barnum and Bailey reference. So why don't we go with Barnum and Bailey? Tell us about that.
One of my first cases was a guy had gone to the circus and he got a beer, and then the lights went down and he decided to still climb over to get to his seat. And he climbed over a railing that was there for a reason. There was a little hole in that area that had been cordoned off, and he fell and had obviously injuries from that. So I started by taking on that case and taking his deposition, and anyhow, it was not a good liability case for him. But it taught me that I love the facts. I loved learning about human anatomy, which you do in personal injury. I have a phobia of needles. I faint, but reading and getting to know human anatomy is something that I think I've been doing now for my lifetime. Absolutely love it.
So in the needle phobia, fainting, graphic images, those are okay?
Those are okay.
Interesting.
Yeah. We will see a lot of gory things in our line of work on either side, and I love it.
I said there were two things. I actually wrote down the other so I could remember to go back to it. You said that a lot of female lawyers got their start in asbestos, and I didn't want to just let that pass without following up a little bit on it. When you say that, what do you mean? So
we're talking in the 1980s when I was in asbestos, and it was a lot of women. hired by firms. Let me give you an example. When I worked at Fisher & Hurst, we had Raymark Industries as a client. 8 attorneys out of the 50 attorneys that worked for the firm accounted for most of the firm's income. So asbestos was a very profitable area, probably still is. And women, as we were graduating from law school, could find jobs in asbestos. So when you would go to depositions, they'd be over at Aiken and Welsh in a court reporting agency, and the room would be filled with mostly women. So I have a lot of really good friends from those days.
Interesting. Are there still friends of yours from those days who are practicing in asbestos?
Yes. I think Patricia Henley. I met Mary Alexander actually way back then. But Patricia's still working with Al Brayton.
You mentioned liking depositions. Can you tell us a little bit more about what it is about the deposition practice, preparation, being there, engagement with opposing counsel? What was it about depositions that you particularly liked?
Well, let's start with the preparation. I think any good trial attorney does a lot of preparation to get ready for the deposition. Usually we know more than the deponent is going to say. But you ask a lot of direct questions, so you're learning more. You're learning vignettes, stories in their life, whether it's plaintiff or defense side. And I love learning about people, learning their life story, their little twists and turns. So I'd have a roadmap based on my preparation. Let's say I was on defense side. I'm looking through stacks and stacks of medical records. Medical records are a great way to learn about somebody's life. They always have the social history where you can learn a little bit more about marriage, kids, alcohol, tobacco, but also social workers will put in notes. So you learn a lot from that. And then when you go into deposition, it's like peeling the layers of an onion. You go deeper and deeper and deeper. And you're just getting these incredible stories that you can whittle or hone and use for trial purposes. So I find, and it might be as a female trial attorney, that we're very versed with schmoozing conversation. We talk to our girlfriends. That's kind of our currency. So taking depositions is both fun and energizing and pretty easy. Just want to really get to know the other person.
Is there anything that you would want to share with, say, a younger lawyer about deposition preparation that you think is something that kind of helped your skills get above and beyond the everyday lawyer?
Sure. Let's take it another way. I think the most interesting part of trial is cross-examination. I think everybody should be able to do a good direct exam, right? And so when you're taking a deposition, that's mostly direct, but when you're taking an expert's deposition, which is another level, I think young attorneys should prepare. When I would prepare for an expert deposition, well, I need to get everything I would have to win at trial. So I would meet with my own expert ahead of time and learn what he or she, for example, orthopedic surgeon would tell me were problems in the other opposing counsel's case. And I would read every single medical record. I'd have them, indexed, paginated, my own chronologies, so that then when I was asking my questions, again, still getting vignettes from experts, but then getting them on track to what I really needed to learn, and a little bit of cross-examination like questions in there, so that by the time you're done, you should feel like you know everything there is to know about that expert in the case. Another thing for young attorneys is don't be afraid of time. When you're in a deposition, sometimes experts will play a little game. I had one expert once, a neuropsychologist in a brain injury case. I went out to his office, and back then we drove to the offices, and that could be an hour, 2 hour schlep. And within an hour, they said, my time's up. And I said, oh no, I reserved for 2 hours of time, paid for it. They said, okay. I said, can you please give me your medical bills, or I'm sorry, your billing on the case? And the expert said, well, I don't know if I could do that in this amount of time. I said, well, I think it's before 5, doctor, and I've seen your staff still present. So they went to the front. They took 20 minutes to bring back their bills in the case and said, oh, time's up. Of course, I got a little frustrated and angry because that's a 2 hour drive. I came back again, and they pulled other games in terms of, oh, well, we can't find this, or I can't read this research person's notes. And so I just very calmly and gently led them through what I needed. And I went back a third time. So I think it turned out to be a 6 or 7 hour deposition total, spread out over 3 times. But then if you're a young attorney, spend the money is my messaging. Take the time to carefully go through and get what you need. So if they're giving you answers that are either obfuscating or not answering your question, make sure you keep going after them until you get that information. So you get your black and white script. And then that same expert I had in a brain injury case at trial in Marin County. And they wanted to give me, particularly neuropsychologists, give you long-winded answers, maybe as I'm doing now. And so as he was giving me the answer, I would have to say, please answer my question, because he didn't answer it. And then I would put my hand on what I called my Bible. It was the binder that had his deposition transcript, my page line. And everybody's their page line index is different. Some do it just so that it references where you can find that quote. For me, I organize it by subject matter and what they're talking about. And so I could go back and impeach him. And I believe that expert, I must have impeached at least a few dozen times. Every time he was long-winded and started to talk, I came back to his answer, which was a simple no. And so that was a trial where I got to go out with the jury afterwards for champagne and chat. And they said every time I went to put my hand on that binder, they would smile. And then by the end of the examination, the same expert would say, well, if that's what you said, I said it. Right. And that's when you know you got him.
Yeah. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. One of the things that I would say is a hallmark of your approach is that you're politely persistent. And I would love to know how you can be kind and yet just keep pushing until you get to the point where you're driving back 3 times, or the carrier is actually making the phone call and that next layer is getting involved. However it is, because it shows up in your mediations now in the same way that it showed up in your cases. I think it's a superpower of yours. And so to the extent that you can share with others how you develop that, or whether it's just born.
I think it was just born. You're right, though. I think everything does go back to maybe childhood. And when I was born, I had some sort of knock-kneed issue. And so I physically had braces all the way up my leg for when I was a little girl, I believe before elementary school. Mm-hmm. And that did not deter me. I still went out and played. I was told I would never run. I ran a marathon after law school. You know, I'm a cyclist, a skier. So I think that gave me the determination, the grit to persevere. And that has never left. So I think one thing I'd love to see young lawyers do is bring back more civility in the law. I think you can be a very aggressive and firm lawyer, but do so with kindness and in a polite way. And that's what I always try to do. With that expert, for example, that I had to go back to 3 times, I was very civilized about it. I just paid the money, scheduled it, and came back each time. And then as he would not answer the questions, I'd wait. And then I would say, Dr. So-and-so, we need to talk about this and get this answered. And it might take 5, 6, 7 times before I got that answer. So it's good to persist.
I think one of the things that I see is that people get frustrated and they let the frustration become personal because they feel to some extent that doctor is not answering the question, is being purposefully evasive. And so they try and take it out on the person. How would you counsel that person, that lawyer who's getting amped? Me.
Well, I think you described it well. Obviously, I was frustrated, and I don't like to get back in my car and have to drive again for no reason. But I think you said something really important. I still do it on occasion, maybe you do. We tend to personalize things. And one thing that I learned early on is it's really not personal. They probably have done this to just about everybody. It's their game. And my example would be I had a trial that was worst trial of my career back when I was, I think, 33-ish. And it was in Redwood City. I had, I'll say his name, Judge Peter McGuinn Smith. And he cut me off, and it was a brain injury case. I was on defense. They wanted $3 million. We had offered like $20,000. Didn't believe that there was liability nor brain injury. So the judge cut me off during voir dire, cut me off in opening. I remember going home, and I was a mess because I was usually staying there. I had young children at the time. I came home and I was just crying. And my husband hands me the phone, and I'm stubborn, as you know, and I don't want to take the call. And it was to a woman named Judy Johnson, since passed away. She was a DA in Redwood City. And she had a very famous case that got published in Cosmopolitan magazine about a coach that they were bringing a suit for his being a sexual predator. There's a statute of limitations issue. And she had tried a case in front of the same judge. And she said to me, Deborah, he'll cut you off in opening. I go, he did. She goes, well, I brought a male associate to see if maybe he was just misogynist, which I do think he is, but he was equally gruff. She said, he was going to hold me in contempt of court. And as she was saying this, I realized, you know what? He's just a jerk to everybody. Mm-hmm. Why was I personalizing this? So that gave me the courage to go back to that trial, because I was trying to think, if you get a mistrial, do you get the same judge? What should I do? So I went back to court. And remember, I'm staying in a little shit hotel because insurance company's paying for this. And that trial went for a month and a half. And every day this judge was being abusive. But I realized it's not me. This is just who he is. And I'm going to stand up to it. So at one point, my neuropsychologist took the stand, and I didn't realize that the judge had him before and didn't like him. So he calls me up to the bench and he says, you get him off the stand in 5 minutes.
Wow.
So I go back out, and my expert is a loquacious. So he starts to talk about his qualifications. I'm saying, Dr. So-and-so, in 5 sentences or less, could you tell us about your educational background? And after that, the first question I asked was something about the plaintiff's background, and my expert used the word alcohol. We were not allowed to talk about the plaintiff's alcoholism. Boom, gavel comes down. My husband is holding my daughter Danielle, who was 4 years old at the time, in court to see where her mom has been for the last, 4 weeks. And then I had been in a trial 2 weeks earlier across the hall with great Judge Ballhofer. And so the gavel comes down, and he says, I'm going to hold you guys in contempt of court because of the motion in limine. And so I had to think fast and truthfully said, well, I did advise all my experts about the motions in limine, but that was over 4 weeks ago, Your Honor. And obviously they must have forgotten. So judge leaves the bench, gavel comes down. My daughter comes running into my arms. She goes, Mommy, I heard you talk. But that was a trial where I learned, don't personalize. Mm-hmm. If they're a jerk to everybody else. If this expert is frustrating you, certainly I talk to people at night, maybe, over drinks about what a jerk they were being to me, but it is this who they are. And you need to figure out a way around it.
You did something there with that question in 5 sentences or less that I think is worth bringing out, which is embedding stage directions within the question without it becoming a leading question. Mm. Can you expand a little bit on that for those who haven't had to kind of corral the witness who might be going a little bit out of control? How did you develop that technique?
That's actually really hard to do, isn't it? You mean of your own expert when they're on the stand? Or
the witness who you recognize, they don't remember the motion in limine rulings. I need to be very careful. How do I ask open questions without stepping on a landmine?
Right. And hoping that you'll get a break soon enough where you can refresh your recollection on that.
Yeah.
It's interesting. I think that you're actually putting your finger on something important. You are the director in your trial. You are the one that is going to be leading your witnesses and your experts into where they fit in and how much they should say or not. So hopefully you're meeting with your experts before, as you're developing the testimony that you want from them, and then you're talking to them again. It's not just one time, it's probably several times over the case and certainly in your trial. And then sometimes I'll say, so this is an area I'd like you to expand on. Please, few paragraphs. This is an area that I think, while it's interesting, we don't need to talk a lot about because I have another expert who's teed up to do that. And so you really need to know your expert, know where they tend to want to talk too much, especially with your psychologist and neuropsychologist, maybe psychiatrist, and kind of give them more direction on where that should go and then hope it works when they're up on the stand. And if they're not following it, then maybe you take a break. And then at break, I certainly will tell them.
We, as trial lawyers tend to do, we quickly lapsed into discussing trials.
Yeah.
Are there elements of trial that for you, either when you were younger or through your practice, were more of a challenge, more evoked more fear or more concern, or took more time?
I always put a lot of time in, so that'd be hard. Even a small case for me, you still put the time in because you don't know where it could go. But in terms of fear, I had one case that was in Marin County, and the plaintiffs, I was doing defense, the plaintiff's counsel, very good attorney, had an in-house exhibit maker. And he had a very nice PowerPoint presentation that I had to go drive to Emeryville, talk to the carrier, show it to them because they never want to watch them the day in the life of or whatever. And I thought he did an excellent job. And I was a little fearful of whether we had put enough money on the file. When you do defense side, at least my thinking always was, I want to put enough money on so that I can beat that at trial. Otherwise, it should settle, right? And so I was a little fearful, and we got ready for trial. This is one where my daughter, and this might happen with you, with your son and daughter, she was thinking of law school and had a gap year after college. And so I had her come and do my tech. She could run the tech, she could do my exhibits. And here I have my mind, oh my gosh, my opposing counsel has this built-in exhibit maker, and I'm going to be doing ones that we've just made ourselves. And so she did a great job, though. She was creative. They were colorful. And so when the trial ended, the jury asked who my exhibit maker was. And so I proudly looked over at my daughter and said, well, my mini me. But what was cute about that, and you have to be careful when you bring your kids in, we were just kind of side by side. I was writing my closing argument. She was working on exhibits. Because it was a rather fast trial, I felt I needed new exhibits for closing. So she kept interrupting a little bit. Mom, what about this? Mom, I said, you know what? You have carte blanche. You can be as creative as you want. You have to be careful when you say that. So there had been a theme in the case. It was a traumatic brain injury case where he also claimed an aggravation of his MS. And so he said, yeah, right. The neurologist said, well, I said, how do you tie this in causally? And he said, well, it's like a purple cow. You'll know it when you see it. So my daughter had a purple cow in one of the exhibits. And my client had been driving a white truck, and he lived on a dairy farm in Nicasio. And so one of the little rubs in the case was they thought when he brought his vehicle in to be inspected that he had purposely put cow dung all over his truck.
Interesting.
It was because he lived on a dairy farm that occurred. So she drew that truck with the purple cow. And when I saw that come up, I thought, gotta be careful in the future when I say carte blanche, but it all worked out well. And by the way, that was the same trial that I realized, sure, education was deficient. We had failed. We did not show her my cousin Vinny. We did not show her, was it 12 Good Men? We did not show her all the classics. So we watched my cousin Vinny during trial. And I don't know if you do this, but you do personal best. The next day, I used an objection from my cousin Vinny in court just for fun.
Do you think that exposure that your daughter was afforded was part of what helped her make the decision about going to law school?
Well, it definitely gave her the decision not to become a trial attorney.
Interesting.
I don't know what led her to go to law school, because she saw two parents that worked extremely long hours and hard, and initially didn't want to be a lawyer. So I don't know what eventually led for her to go to law school, but she now does more transactional privacy data over at in-house counsel for Verkada, and didn't want to do trial work, although she was excellent on her feet when she was in 5th grade and did, it was the 3 Little Pigs and the Big Bad Wolf that we did in court.
That was a mock trial?
I did that for her in 5th grade, her 5th grade class, and my other daughter's 5th grade class.
Oh, that's neat. Who won?
Each time it was different.
Was it a criminal trial or was it a civil trial for?
It was a criminal trial, and we did it in Marin County Courthouse 1 year after the other. And the students were the bailiffs, the judge, the wolf, and some have become really good attorneys since then.
Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.